Gemma Barnhurst and I'm with Graeme Fraser, partner and head of family at OGR Stock Denton. We're here today to talk about cohabitation policy, in particular the responses to the Parliamentary Inquiry into the rights of cohabiting partners. Good morning, Graeme.
Hello, Gemma.
So, do you think there should be a legal definition for cohabitation, and if so, what should it be?
Yes, I think it would be helpful to have a definition. In countries where there's no definition, it can cause confusion. We believe the definition should be based on a committed relationship between two adults who live together as a couple, and they've either lived together for a minimum period, demonstrating stability and commitment in the relationship through permanence, or they have a child together and are not married or in a registered civil partnership. So that's the lack of formality aspect. Where there are no children, cohabitation can be demonstrated by showing commitment and interdependency. We say that 2 years is long enough to demonstrate that commitment to the relationship and minimise the risk of claims which we would see as being unmeritorious. And it's also consistent with other domestic legislation, for example, financial provision claims on death for cohabitants. Where cohabitants have children, we say that there should be no minimum period because the existence of having children is enough.
Okay, so what legislative changes are required to better protect the rights of cohabitants on death or separation?
Well, at the moment, it is possible to live with someone for decades, have children together, and then walk away without the commitment that we expect the economically stronger party to take for a former partner when relationship breaks down. We say that happens too often in practice. So we're calling for a legal framework of rights and responsibilities when couples who are not married or civil partnered live together and split up. And that would provide some legal protection as well as secure fair outcomes at the time of separation. In particular, we're looking for cohabitants to meet eligibility criteria and then have an automatic right to apply for financial remedies unless there is a situation where a couple chooses to opt out. So that's fundamentally it. What would happen is that the court would make the same sorts of orders they currently do on divorce or dissolution of a civil partnership, but it would be on a very different and limited basis to divorce. This would allow flexibility to the court to adjust property rights and also allow the court to tailor its orders to particular circumstances so that they're fit for purpose. The sorts of awards that could be made would include payment for childcare costs to enable the primary carer parent to work. We also say that cohabitants should have the ability to apply for spousal type maintenance for a limited period, which would enable a cohabitant to adjust to the loss of financial support before becoming self-supporting. Perhaps that would be for a period of, say, 3 years. In the event of death of a cohabiting partner, we say the surviving partner should have an entitlement of intestacy subject to conditions, and there is draft legislation in place that would enable that to happen. We also say cohabitants should be treated in the same way as married couples and civil partners for tax purposes on death.
Okay, and what equality issues are raised by the lack of legal protection for those in cohabiting couples?
Well, essentially, the equalities issue comes down to the concept of relationship-generated disadvantage. That's a very well-known concept in English law because it's been the case for over 20 years now in a divorce scenario that there is to be no discrimination between the roles that the parties decide to adopt during their relationship in terms of who goes out to make money and who looks after the children. And this is something that often actually isn't decided consciously, but the couple realise what their roles are. We say there should be recognition for that, as there is in financial remedies on divorce or on dissolution of a civil partnership. We also say, therefore, that a economically weaker party's position could be weakened because of decisions made such as bringing up children, elderly relatives, And all these things should play a part because their financial position has been significantly compromised. As women are those who tend to undertake the majority of caring responsibilities, we say, and it's been proven actually in terms of the cases that we see, that the lack of effective remedies disproportionately affects them, and therefore the present state of the law can be seen to be discriminatory. It's also a feature that age has a very strong effect on the likelihood that someone will believe in what's known as the common law marriage, which actually is a myth for all intents and purposes. That's the belief that it's a mistaken belief that by living together with someone you have the same rights as you would on marriage. Now it turns out that consistently there have been a series of British social attitude surveys, and the latest one of those was published in January 2019, which showed that still around 52% of people between the ages of 25 and 64 believed in that myth. And as that is the age group who are most likely to be affected by it, they are the ones who are most likely to suffer. So clearly age has an impact. The other aspect that is important to look at is religion. And it's possible in England and Wales to have a religious marriage which is not recognised. And this can significantly impact what happens on separation. Because instead of having the rights that you would have on divorce or dissolution of civil partnership, the couple will then go on to be treated as unmarried. And as a result of that, they have the same treatment as cohabitants, which means that they will have little or no legal protection at all when they separate, and that can be regardless of how long they've been together in their relationship, or whether they have had children or property together. So lots of lacunas in the law and lots of inequalities that we have seen.
Yeah, and would you say that cohabiting partners should have the same rights as those who are married or in civil partnership?
Well, clearly there's a difference. We know that cohabitants have not made that decision to make the public commitment of marriage, but at the same time, that doesn't necessarily correlate to a commitment to the relationship. And that's what we're looking to respect and recognise, namely committed relationships. What we do know is that the number of those cohabiting, many of whom have dependent children, continues to rise and is projected to do so for at least the next 10 years. And we say that as those numbers change and increase, there needs to be an acceptance and reflection of what is happening in society and the law, and in particular to protect the vulnerable. We do say, however, there should be a difference between marriage and cohabitation as far as England and Wales is concerned, and there should be some finality, and there should be a presumption built in that as far as possible each of the cohabitants should leave the relationship self-supporting.
Okay. And are there any examples of good practice either in the UK or internationally that you think that the government should seek to adopt?
Well, there are lots of examples of countries which have cohabitation legislation in place. We can look at Europe, Oceania and America, including Canada, Latin America, Australia and New Zealand. So lots of different examples. What we say about a new law is the importance of any legislation that's brought in this country would need to provide clarity, be fit for purpose and actually useful for the public and useful for people operating the law. So it must help people. Australia is a good example of the opt-out system, which is very simple and clear, and basically it enabled the federal courts in Australia to bypass convoluted property law, similar to the property law regime that exists in England today. Very difficult for the public to understand and also practitioners. Now, what's happened in Australia is regardless of marital status or gender, all couples are now treated substantially the same when it comes to property and also maintenance. And Australia has got a very workable system, and there was remarkably very little or no objection to its introduction when it came in. So we do know that new legislation can, in certain circumstances, cause little or no controversy. I know that can be an issue for policymakers and the government. We consider as practitioners that a discretionary system would fare much better in England and Wales than it has done in Scotland. Scotland was the first country in Great Britain to introduce cohabitation remedies, but they were used to a fixed system with quite a lot of rigidity. In England and Wales, we have financial remedies in divorce that already operate using a discretionary basis, and that's something that practitioners understand, the courts understand very well. It's very workable. What we say about the new law is that if you have access to a wider menu in terms of remedies, and it's well established, then that can be used and applied in practice and would lead to fairer outcomes. The discretion, however, there needs to be a demarcation in terms of how they would be applied, and it would be restricted to compensatory claims as opposed to the wider claims, the far wider claims of needs or sharing that are available on divorce.
Great, thank you. I hope you found that informative, and we will see you next time.